We had great communication and a chat last week wise. This is our second one for the month of November. Some great information. Elaine sent me a scary email this morning. So I'm very excited to get into the details on that one. So glad everyone's live on this so they can hear what Elaine wants to talk about rent reductions. We're going to dive deeper into those. And it sounds like she has some caution against that because of the new legislation wise. So definitely always good to know that. Because some of the things that I say, I can tell everyone I learn something every single time I do one of these with Elaine. You know, sometimes I say things and then she corrects me because I think I knew what was right and I was wrong. And specifically in this instance wise, this has changed from week to week. We have brand new legislation that's out there wise. So the content that's coming today will actually be different than the content last week because we have some clarification on some things. So Elaine is such a resource wise, because if you end up going down the road of the landlord and tenant board, and our goal always of all these is we want to avoid the landlord and tenant road. We don't want to go down that road. Everything we tell you today is to prevent you from going down that road. It doesn't, when you run into an issue with a tenant, it doesn't mean you're going to go down that road. We're just trying to prevent there being a reason for you to go down that road with a tenant wise. Everything is best handled through dialogue and communication. And if you're not comfortable having that communication or you're having issues having that communication, Elaine is very good at having that communication. And I've personally used her services in the past. I own a property management company. Our property management company uses her services. We highly recommend her. And if we watched my videos in April wise, or our videos in April wise, here's the thing. You own a property. You have hundreds of thousands of dollars invested in that property, if not more, with your own personal cash and equity wise. So, you know, that is a very, very big investment. On the other hand, this is someone's home, and that is very, very important to them. So even though you own it, someone views this as their home. So those are two very tense things. You're impacting someone's home and someone's impacting your money. And that can cause a lot of tension between two parties wise. So sometimes getting a third party involved in those communications can help alleviate those tensions because if you look at, again, someone's home, if someone messed with your home, would you be pissed off? Probably. And if someone messed with your money, you're going to be pissed off. So that's where you get a lot of tension between the two sides. And sometimes it's always better bringing a third party in. Okay, so we're at 11:05. We'll get started. Thank you everyone for coming on and taking time with us. Our goal is to educate and help everyone build wealth through the investment in real estate wise. And part of building that wealth is having a tenant in your property wise. And sometimes there can be issues that come up with that tenant. I truly believe, especially on the condo side, that it's one of the easiest ways to earn income in real estate. I'm not scared of tenants. Some people get scared of the whole landlord-tenant relationship wise. So that's why we brought on Elaine. We did webinars in April discussing how COVID could potentially impact the tenant-landlord relationship-wise, especially with legislation that came out at that time where they put a moratorium on evictions for non-payment. So there was lots of confusion in the market. Everyone thought the sky was falling. It was going to be the end. Well, we're on the other side of it now, and it wasn't the end. And I can say for the most part, we got through unscathed. We do have, and when I say we, I own properties. None of my personal properties were impacted wise. None of Kyle's personal properties were impacted wise, but we also own a property management company, and we represent landlords as well for the leasing of their properties wise. Out of over 100, we only had one where we had to actually take action to landlord and tenant board and for non-payment of rent. But other than that, we got through for the most part unscathed. There were definitely conversations that people had. There was some delay of payment wise. There was payment arrangements that were made with tenants wise. It wasn't a smooth ride, but again, for the most part, everyone got through unscathed. And through that time, a new legislation came out. Evictions were opened back up. The Landlord and Tenant Board opened back up, and Bill 184 came out, which we're going to discuss more today. But as I said, we have Elaine with us, our expert paralegal, award-winning paralegal, a recipient of the Paralegal of the Year for Ontario previously, and we have our co-founder of Remax Wealth Builders Real Estate, and also an investment guru, Kyle DeVici, on this call, and then myself, Alex Wilson. So thanks for everyone for coming on. So we have that preamble. We made it through. We made it through the unknowns of COVID in April and May. The landlord and tenant opened back up. Eviction hearings started to proceed again. So why don't we start off with that, Elaine? We know that the landlord and tenant board is open back up. But if I did have to bring action, what's that looking like for me, and what timeframes am I looking at?
Well, if you were bringing an application today, we really don't know when. It depends on the application. We have no clue when a hearing might be. I can tell you that in the next 10 days, I have something like 38 hearings, and which is getting caught up on all the backlog. And so some of those are from February, March, and April. I haven't got anything around May, June, July yet. So it's going to be several months, and there is concern that we're going to do another shutdown of the board. Now, there has been nothing officially said. The board, the Ontario government hasn't indicated that that's happening. There's just a lot of rumors. So I just want to put the caveat out there. Don't listen to the rumors until it becomes fact.
Yeah, that's great advice. And a lot of this, you know, we if somewhere on early wise, it's all about communication with your tenants wise and trying to work out some sort of solution wise. So you heard from Elaine that they're now hearing cases that February, March, April, those were the applications. We're in November right now.
Yeah, and I just want to say something about the applications that are the hearings now, because there's some confusion on this. There's a new form that the board put out, particularly for L1 hearings, which is the notice of termination for non-payment rent. And under Bill 184, the tenant actually has to advise the landlord if they're claiming any maintenance issues. They can't just do a trial by ambush and show up. So the form, there's a package of forms that get sent to both the landlord and tenant. And in that is a sheet for the tenants to fill out if there are outstanding maintenance issues. And then it says, e.g., the roof was leaking from whatever day to whatever day. And I have clients calling me panic going, we don't know anything about a roof leak. So they're not understanding that it's just an example, that the roof isn't actually leaking. So if you get one of those, the roof is, unless the tenants filled it out, the roof is not leaking.
Yeah, and you know, forms are so important, and we've said this, probably bring it up every one of these webinars wise. If your form is not filled out correctly, it will get tossed out. And even if you think it makes common sense, going, well, that's an honest error. Obviously, this is what I was trying to say. It doesn't matter. They're just going to crumple it up and throw it out, and you're going to start all over again. And we've talked about these time frames. So you really.
So let me just speak to that for a minute, if I may, Alex. Yesterday, as recently as yesterday, I had a client come to me to retain me to do a hearing on November 27th. Her property manager had filled out the N4, which is the notice of termination for non-payment of rent. I said, sure, no problem. Let me make sure the N4 complies. I opened it up and it was completely wrong. And then I looked at the certificate of service, and the certificate of service said that they had served the N4 by email. You're not allowed to serve notices of termination by email. There are some documents that you can serve by email, but not notices of termination. And I had to tell this poor landlord who it was her birthday and I ruined her day, that, you know, even though the tenant was 6 months in arrears of rent, that the application was going to fail. And of course, she was really upset. So one of the things that bothered me about that is the notion of property managers filling out these notices. They don't have insurance. If you use a licensee of the Law Society of Ontario, if we screw something like that up, we have insurance to cover you and protect you. Property managers do not have that kind of insurance, and these poor people will lose 6 months rent or more, because if I have to start over, it's more likely going to be 9 to 12 months rent. All because this property manager, and who was arguing with me about why he thought it was right, they're going to end up losing. And I mean, I'm certain that there's litigation that's going to flow. This property manager is probably going to get sued down the line. And so for those of you who have property managers, I'm sure they do a great job in so many areas that they're managing, but don't have them fill out your legal documents for you.
Yeah, and I can say, you know, how Elaine and I initially met. You know, I bought a property. I was going to move into it. The seller of the property filled out the form on our behalf because they have to. I can't fill out the form. I don't own the property yet. I have no relationship with the tenant. They filled out the form. It was incorrectly filled out. Tenant didn't move out. I was homeless. Luckily, I had somewhere to stay, but I was homeless. Elaine jumped in. Elaine mediated the situation, and we were able to get in the property earlier than the potential length of period that it was going to be. It was delayed. I think it was 4 to 6 weeks that we were expected to get into it, but it could have been 3 to 4 months for that instance wise. And it was all just simple form was incorrectly done. And recently I referred Elaine to my mother-in-law who was in a transaction wise. And I said to my mother-in-law, you have to just use Elaine. She could have filled the forms correctly. Have Elaine handle it. This is a massive transaction wise. Just pay a little bit of money, no headaches. I'm like, you don't want to, and what the instance was, they had sold a tenanted property and there was notices that were required in the agreement to be completed by a set time. So we're hundreds of thousands of dollars. And if things are done incorrectly wise, then you get into lawsuits and everything like that. I said, just have Elaine do it. Form's going to be done correctly. Boom. No more worries wise. I can't stress enough how important these forms to fill them correctly will be. Just again, throw common sense out the window. It's dotting I's and crossing T's in this one.
We see this a lot of time though, Alex, where many people reach out saying, oh, I can save a few dollars. I can fill out this form, do it myself. If it's painting, recaulking a bathroom, sure, go ahead. When you're serving notices, evictions, bring in the professionals, pay the money. It will save you money in the long run.
I can tell you, I don't know all the answers for this. As you're going to see in a second, Elaine's going to correct me, correct even just the last webinar and something wise. This is bureaucracy. This is red tape. It may want you may want to pull your hair out. Elaine's an expert in the bureaucracy and red tape of the Landlord and Tenant Board and Landlord and Tenant Act, which is always evolving and always changing, especially in these days. So we are just trying to save you headaches wise. Oh, Elaine, like we had this, Elaine, remember that email exchange that we were having the summer wise and someone was angry with you and we basically said good luck wise. What it was is Elaine had provided some advice to someone and then was like, oh my God, like you're sending me an invoice for this? And it's like, they brought me in and they're like, they wanted me to do something about it. My response was and basically said, I'm never working with you. So bye, you've missed that opportunity. And number two, I strongly advise you to find some sort of other representation because Elaine's not going to work with you now because of your outburst, because you are going to lose thousands on thousands of dollars if you don't rectify the situation immediately. And they had a tenant that was non-payment of rent. And then there was also a vermin issue or that the tenants had developed in the property and the city was providing notices to the property that there was an infestation of cockroaches wise. The thing was just getting worse and worse and worse. And the person was upset that they got a $250 invoice. That is the last thing of your problems. That is the last thing of your problems. We're trying to get you a way out, and you're upset that you're getting an invoice for $250. Come on. So, anyways, I don't know where I'm going with this, but let's before I go deeper down a hole, Elaine, why don't we talk about, you sent me the email about rent reductions wise and Bill 184 and the new regulations on that.
Okay, so this was a bit of a shocker to me because I don't generally deal with rent in terms of setting rents. I mean, you know, other than to let people know how much the increase is for the next year. It's usually the landlord or the property manager's job. And so I was asked a question last week around how much can, you know, how long can you do a rent reduction? And my immediate response was 11 months, because I know that after 12 months, it becomes the lawful rent. But what I found out was that I was not correct. I have a client, a corporate client, who contacted me and said, I don't understand section 111 of the act with respect to reduction of rents, and I need guidance. And I said, okay. And I looked at it, and it took me about 3 or 4 hours to figure it out. So section 111, and I'm just going to put it up on my screen because I have it. I thought I had it ready. It's here somewhere. Anyway, section 111 is basically the section that, and it's not new, this is old. In fact, it's archaically old. It's a section that deals with how to reduce rents, and it has this crazy language in it. I'm not gonna read the whole thing to you because it's lengthy, but you have to read it in conjunction with the regulations. And it talks about lawful rent is not affected if one of the following discounts is provided. A discounted rent at the beginning of or during a tenancy that consists of up to 3 months rent in any 12-month period, if the discount is provided in the form of rent-free periods and meets the prescribed conditions. And then, so even there, like, that's just confusing all by itself. When you go into the regulations, it talks about, it is the most convoluted thing I have actually ever seen in my life. It talks about you can provide a rent reduction that's equivalent to 3 months, but has to be taken as full rents on the first and second month and partial rent on the third month. And don't quote me on that because that might not even be right. It's so convoluted. And then it talks about being able to take a rent reduction for the last 5 months of tenancy. Well, I don't know when the last I mean, I left my crystal ball at home. I do not have the last 5 months of tenancy. So how do I figure that out? And the risk is that if you lower the rent or you do a rent reduction, and you don't do it in the way in which it's set out by the regulations, you risk having that reduction a permanent reduction. And if you ask me to define and give you kind of a snapshot of what that regulation is, I can't. It is so convoluted. And it never anticipated that we'd be living in a pandemic and that there would be en masse landlords wanting to reduce rents. Yeah. And so the bottom line that I'm actually telling people is don't reduce your rents. That's what I'm saying, even though I understand fully well that we've got a unit that is, let's call it 1,200 square feet in one building, that's the rent is $1,500, and because of the market, the exact same unit across the street is $1,300, and you want to keep the tenant, so you want to reduce the rent, can't do it. So now you're going to lose that tenant. I understand that there are very many compassionate landlords out there who feel badly because their tenants are in dire situations and want to reduce the rent. Again, in 3 months, 4 months time, you might find yourself in a position of saying, uh-oh, because I didn't do this correctly, I've made this permanent. Now forever and ever and ever, it's due to $300. So my recommendation is don't reduce rents, which sounds crazy. I get it. So what have I done about that? I've actually reached out to, and this shows you about community. There are a number of lawyers who work in the legal aid clinics, the community clinics, who are strong tenant advocates. They're the ones who sometimes set up some of the things we don't like, which is the protests and all of that stuff. But they're smart people. And so I reached out to two of them and I said, this is, I know it's strange, I'm a landlord rep, but this is totally wrong. And we went through it and they agree and they're sort of looking into it themselves. And I'm also looking into getting the press involved because pressure needs to be put onto the government and quickly to make a change. There is no situation in making that change that anyone loses. Landlord wins because they get to maintain their tenant and assist their tenant if they choose to. And tenant wins because they're getting a reduced rent. So across the board, there is no downside to this. So stay tuned. I'm raising a ruckus, but in the short term, I'm going to tell you my best advice is don't get caught, don't get trapped in making a mistake. And I can't even advise you how to do it correctly because I don't know.
Yeah, my answer would be is if you do it wise, just know that
it's risk.
It wise. That your worst case scenario is that let's say market is let's say your rent's 2,000, market's 1,700. Tenant comes back and says, I'm leaving if you don't give me 1,800, let's say. And you agree to a reduction, as we said last week, of $200 per month for an 11-month period, because you want to have the ability to go back up to the 2,000. Now, we don't know if that can actually be done because of how the Landlord and Tenant Act is currently structured. Otherwise, is not structured for this situation. Worst case scenario is you're stuck at 1,800, but you're still better than if the tenant left and you have to find a new tenant wise. So just if you're doing a reduction wise, don't do a reduction of from 2,000 to 1,000 and then you're stuck at 1,000 for that. That doesn't make any sense. But if your option is reducing it and maintaining the tenant, but you're still at or above market rent, you're okay. You just don't know if that's going to be permanent wise. And this is where communication with the tenant comes in. This whole situation that Elaine is discussing wise is if the tenant went back and said, hey, you know what? Nuh-uh. I'm not, this is permanent wise because of the Landlord and Tenant Act, that kind of thing. And then you go to battle at the Landlord and Tenant Board. If you guys are having regular conversations and working with each other, common sense can apply when you work with a tenant and the tenant works for you. Your common sense approach when you get to the Landlord and Tenant Board, that goes out the window, and then it's a dot the I, cross the T situation, and the third party is deciding your future wise. So the answer to the question is realize what you're getting into and the potential danger, the worst case scenario danger wise. But if you operate in the parameters that if the tenant is leaving or if you reduce the rent, but the rent is still equal or greater than what the current market is, then you're better off still reducing it wise. And then if there's a situation where the tenant's like, well, that's permanent, I thought it was permanent wise, then you can have another conversation to see what you're going to do with it wise, and you may be stuck depending on what legislation brings. So,
right. And so this is particularly problematic because, with one of the changes of Bill 184 that has been actually proclaimed, not all, as I said last week, not all of Bill 184 has been proclaimed yet, but this section that talks about offering payment plans and such for tenants during COVID has been proclaimed. So when we go to the hearing, the member will say to us, and has there been any discussion or any offers to for payment plans or reductions? And if the answer is no, we're not going to get an order. If the answer is yes, then we will. But so they're encouraging us to make these deals under the Act. And yet there's this contrary section of the Act that is extremely problematic. So I'm actually a little surprised that nobody has sort of jumped on this yet. I will tell you that in the past, we had many years ago, I think it was 2014, we had a situation around supportive housing where a supportive housing organization would rent, a corporation would rent from the landlord, and then they put in one of their people. And then we'd have a problem with the people. And it became a question of who's the landlord, who's the tenant. And it became a real dicey issue because we're dealing with vulnerable people. And ultimately, we ended up taking a test case to the board. And I was acting on behalf of the landlord. And the argument I made was, I actually don't care who, the outcome. We just want direction. It doesn't matter to me one way or another. We just need to know, are we going left or are we going right? And then they came up with a decision and now we all know. And I'm contemplating doing something similar with this issue, which is to bring an actual case in front of the board and get a determination and a precedent so that going forward we can do this. And it's one of the things that I've talked to the clinics about. I don't know that it's going to happen through them, but it is one idea for us to push this issue forward.
So we hope we woke everyone up this morning with this great news. So what else can we add here? We've talked about this in detail wise. We talked about what other items are there in Bill 184 that people should be cognizant of?
There's compensation that has to go to tenants on purchaser's own use and landlord's own use, where before there was only on one. I think one of the biggest changes is around bad faith applications where landlords have been found to be in bad faith for giving what's called an N12 notice, which is a notice of termination for owner's own use or purchaser's own use, or an N13 notice, which is a notice of termination for renovation. And under the N13, if you terminate a tenancy for renovation, you actually have to let the tenant back in at the same rate of rent. So a lot of people were playing this game where they would terminate on that basis. They wait a year or two before they do the renovation, and the tenant moved on and then said, we can now re-rent it to whoever. So some of the things that have happened in Bill 184 are protections for tenants around that kind of behavior, and the fines have increased substantially. It's $50,000 for a person, it's $250,000 for a corporation. Also, you would probably have to repay back all of the rent that the tenant paid in the last year, and the difference in rent between the two units, their old unit, your unit, and the new unit that they've moved into for a period of a year plus moving expenses. So it could end up being a very, very expensive proposition for you, and that's probably the biggest change in 184, as well as our ability to, and this part has not yet been proclaimed, our ability to deal with utilities and hydro at the landlord and tenant board, because up to now we have not been able to do that. And likewise, when we have tenants who have vacated and they're either done damage or they are in arrears of rent, we will now, as soon as this section gets proclaimed, be able to go after them at the board. Before we had to go to the small claims court, there was a lot of problems with jurisdiction about what the board's jurisdiction was, what the court's jurisdiction was. And so Bill 184 clears that up very well, actually.
Yeah, we talked about that last week, Wise. So basically, we in our previous webinars in April, Wise, there was change in legislation again, and we didn't have an answer on how do you go collect outstanding rent. So now you actually have the ability to go after the tenant. So basically, and Elaine, correct me if I'm wrong, if the tenant owes you X number of dollars, Wise, let's say they're 6 months in arrears and they've taken off, you would go to the landlord or tenant board, apply. The landlord and tenant board will go, yes, that tenant owes you that money. Then they will put towards an action wise to do that. And then at that time, you can then take that action to the small claims court to then go after that tenant for that amount. Is that correct? The process wise?
Not quite.
Okay, good. Okay.
So when this comes into fruition, it has not yet, as I've said, you'll have to actually know where your old tenant is, and they have to be served personally. There'd be an action for, let's call it arrears of rent, post tenancy. The board would make an order. If they ruled in your favor, they'd make an order for the money. And once you have that order, then you can transfer that over to the small claims court for enforcement. So in the same way that you could transfer an order to the small claims court for enforcement now with orders that you already have. Now, the court will receive that. They're not going to do anything with it. It's up to you to issue garnishments or do whatever it is you're going to, seizures, that kind of thing. So that's how it works. So you don't need to duplicate the action. You already have a court order.
Okay.
You don't need to then file a new claim at the small claims court.
Okay, so yeah, so you get an order from the landlord and tenant board, and that order goes to the small claims court. But then it's on you to then seek remediation or the ability to get that money, the actions that need to get that money wise. But one of the things we got excited about, and we talked about the last one, is that at that point, then once that order is then passed along the small claims court, and you can then, as you said, garnish the wages wise, but it can also then go on the credit report wise. So then you've actually tagged that person, you flag them. But as Elaine said, you got to know where the person is. So you would have to know where that tenant has gone to for notice to be served to that individual wise. So it's kind of like if you're watching, if you watch any of the legal shows or anything like that, and it's like, you've been served. That has to happen. That's the very, very first step, is you need to know where that person is. Elaine's laughing.
Yeah, we try not to be that dramatic. We don't like to get punched in the face.
Yes, but
we're funny that way.
That has to happen. You need to know where the person is. Then documents have to be delivered to that individual wise,
right.
To serve them. But we have an answer to that for people that are. And again, we said it last week. A lot of the times, landlords just want to more alert other people and just make sure that person is not getting away. They would like their money back, but a lot of them are like, I've written that off. I don't know if I'm going to get it, but I don't want to let that person get away. And that's why they want to do some sort of pursue some action against the individual. So it's not always monetary, though. Again, when we talked about last time, sometimes that number can get quite high. So it does become more of a monetary issue wise. But a lot of landlords don't want to allow people to get away with it.
Right. And those orders are good for 20 years. So you may not know where someone is now. This happened to me. I had an order against a tenant, and I walked into, it was many years later, and I walked into a dog bakery. And I'm like, gee, that person behind the counter looks really, really familiar to me. And she recognized me, and then yeah, I have an order against her. And called the landlord and said, guess what? And we actually issued a garnishment and got the money. So it just happens that way. Just drop back to something you said about credit bureaus. One of the things that I would like to see you have on your new leases is a clause that says that you're allowed to A, do a credit check, and B, do a credit, file a credit report. It's more of a protection, with all the privacy stuff and everybody getting all anxious about privacy. If it's in your lease agreement, then it gives you some benefit in terms of being able to do it without getting somebody all up in arms.
Which I do believe it's in ours. I do believe it's in.
I'll have to check. I think it is too.
Yeah, I think I have in ours. But again, if we do have realtors come on here, or anyone that's doing lease transactions wise, you may want to have a clause in your agreement wise. Again, it's just to your benefit wise.
Yeah. Now I have a colleague who keeps saying he's retired, but he isn't quite there yet. His name's Harry Fine, and Harry is a former adjudicator at the Landlord and Tenant Board, a very, very smart guy. And he created a forms package with all of these clauses. Like there's hundreds of clauses that you can add into the standard lease agreements. And people often ask me to draft leases, and I actually say go buy Harry's package, because it's going to cost you more to have me draft it, and it's already all there for you. All you have to do is cut and paste. So that's if anyone's interested in that, it's Harry Fine, Harry Fine, Fine, his form packages. And if you're doing a lot of leases, if you're a real estate agent, I would absolutely be investing in that, at least for the office, because he's really nailed it down very well.
Yeah, and that's where it comes down to. There's clauses you can have and you can't have. He would have the clauses that can be added to the Ontario standard lease, because there are a lot of things that are just garbage in there. And they're my lease package too, that I know they're garbage, but I tell people it's more of a statement, a guideline we like to see, but we know there's no teeth behind it.
Yeah, and as you know, Alex, anything that is contrary to the act, if it's in the lease agreement, is not binding. So,
yeah, exactly.
I always tell people, you can have in your lease agreement, you can hop on every second Tuesday of the month, the tenant has to hop on their left foot for 3 minutes. You can put that in your lease agreement. Put anything you want in there, but it's totally unenforceable.
Exactly. And you know what? And I'll take the most common one, the non-pet clause. Okay. So you can't actually tell a tenant that they can't have pets in the unit wise. Is it in my lease agreements? 100% it's my lease agreements, but it's completely unenforceable wise. The only thing that a tenant does have to abide by is if you have a condo building, there's bylaws in the condo building. And if the condo building said no pets, then they can't have any pets. So it's the bylaws they have to abide by. There's actually very few buildings that actually have a no pets in their bylaws wise. So again, if you walked into your unit and there was a pet and they're going, I said you can't have pets, there's actually nothing you can do about it. Pets are allowed. Well,
It depends.
I know where it's a nuisance wise, or if there's allergies, that kind of thing.
Yeah. I mean, I do have people who have severe anaphylactic allergies to pets, to pet dander. Mm-hmm. And in those cases, we certainly can assist them. Yeah,
of course, but don't lie and say you and then you don't. You'll get caught. So you know what? Let's open it up to questions wise. If you have any questions, we see people have been already utilizing the question and answer bar. We have 6 questions lined up already, 7 now. If you have any questions, put them up on there. Elaine can see them as well. So we'll start with Kim. Kim wrote at 11:07. Hi everyone. Can Elaine touch on the subject of tenant maintenance issues? The December 1st guidelines are saying the tenant needs to let the landlord and landlord tenant board know at least 7 days ahead of a hearing. It is up to the adjudicator to let the tenant present at the hearing without the following protocol? ?
Yeah, so this is kind of what I was talking about before, where we were doing trial by ambush. We'd show up at a hearing for arrears of rent. The tenant would say, the ceiling has been leaking raw sewage for the last month. And all of a sudden we're required to respond to that and no knowledge of it whatsoever. So the change in the act was that the tenant has to let the landlord know 7 days in advance. And this is what I was talking about when I said the example that they use is the roof leaking and that your roof is not actually leaking. So far, I haven't seen anything yet. I mean, when I have a tenant at a hearing, because this is all very new, I haven't had any maintenance issues raised. And I haven't as yet been served with anything from a tenant raising maintenance issues. The expectation is that if they do not serve me with that document, they cannot raise the issue at a hearing, because that's what the legislation says. So what does that mean in real life? It means that an adjudicator may adjourn to another day so that they can raise those issues. It may mean that the adjudicator says, no, you lost your opportunity. We don't know what it means yet because it hasn't, but according to what the act says, if a tenant doesn't raise it, they can't just suddenly show up at a hearing and raise it.
Good. And then Kim, following up wise, what happens if a tenant doesn't show up for their hearing? Do they get a second chance?
So there's different types of hearings. So a case, the board is doing a lot of what's referred to as case management hearings, which is akin to a settlement conference where you and your tenant meet with a mediator and try and resolve the case. If the tenant doesn't show up for the case management hearing, depending on the issue, it may just move to a hearing. It depends on what it is. If it's a hearing and they don't show up, you snooze, you lose. You don't show up to your hearing, then you don't get heard. The landlord will, if everything is done correctly, will be successful. So having said that, I should put out there into the world that there has been a problem at the board. The notices of hearings are coming via email, and a lot of times people are not getting those emails. So if you have a matter that you're waiting for a hearing, my best advice to you is to go onto the Landlord and Tenant Board website, and there's a place where you can check your file. You plug in your file number and your postal code of the rental unit, and then see what's going on, because we've had, and not me, but some of my colleagues have had a lot of surprises when they've done that and found out that they have hearings that they had no idea of.
Good to know. Now, ZG is asking, well, tenants are leaving. This isn't really a landlord and tenant question, so I'll jump on this one. ZG is saying, well, tenants are giving notices because they're leaving for cheaper units that are currently on the market wise. How do I protect myself and not get into locked into a low rent going forward? You can't. There really isn't a way. And I'll tell you, because we do a lot of leases, you're not going to see a recovery to the rental market until 2022. So even really, if you're getting a new lease signed now, it's going to be a year at least until you see recovery in rental rates. That's what I expect wise. So there's nothing you can do about that. The only thing is, if your building is built after November 15th, 2018, that is a non-rent controlled building, that then when it goes more to let's say 2019 rental levels wise, then if my tenant is month to month, then I have the ability to increase the rent in 90 days. We cannot do rental increases in 2021. They've already wiped that out. So for any building, doesn't matter, no rental increases wise. That's been wiped out. So really, it's a market situation wise. If you sign a lease now, you could be stuck at that rent for the foreseeable future wise. That is a situation that you'll have to deal with now. There's no way to protect yourself against that. That's just,
yeah. And this exact situation actually just happened to me, where my tenant left their current unit because they wanted to get a larger one, and the price was going to be actually only just a little bit more. So the only thing I could do was just find another great tenant.
Yeah, and then that's just it's an unfortunate situation. It's just the reality of what it is. So. Yeah, I won't say anything. If you want to reach out to me more fully wise, I can give you some more advice on that. But really, that's the reality of the situation. Kim is back asking about N12s. She filed her N12 in May. Do we have to refile with new forms?
No.
No. Is it okay that we pay 1 month rent by forgiving 1 month rent?
That's a great question, and I don't have a solid answer. In my view, it is, but there are adjudicators who have said that's not acceptable. And it's I have clients who have tenants who are 5-6 months in arrears. They've got N12s, and I'm still telling them cut a check. It's how that section of the act gets interpreted, and some people interpret it one way. Some people interpret it another way. So for me, the best advice, I know it's going to cost you money, but the best advice I can give you is cut a check.
Okay. And then Kim asking, do I need to serve them to put judgment against their credit report? So to clarify, the process is you would serve them to start the process at the landlord and tenant board, correct? That,
Yeah, and then on an N12, I mean, you can't do that on an N12 because N12's for owner or purchaser's own use. But if you have an arrears application and there is an order from the board, yes, you can put that onto their credit bureau.
but again, clear, the order from the board has to occur first, Kim. Once you have the order from the board, then that's when you can take the action and put it on the credit bureau. Abdullah, can you please send us a link, for your friend contact package? Easy, Harry Fine. He's all over the internet wise. You'll see many, many videos. Harry Fine, F-I-N-E. Easiest way, you Google that, you'll find Harry Wise. And I imagine it's just right on his website to purchase one of those packages.
Yeah, definitely.
There we go. Kyle just posted it in the chat to all the attendees there. Now I'm seeing a really long question wise. That looks like a specific question that's in front of the board, right?
I'm just reading it.
In front of the board yet. Okay, so I like this one. I'm going to read this one. I'm going to read this one because this is where you really need to reach out to paralegals when you start running down this path. So, you know, I'm sure you get lots of emails like this, Elaine. I am desperate. I have upstairs and downstairs rented separately. The downstairs tenant stopped paying rent 9 months ago. Owes $9,000. Finally, the virtual hearing is on. Oh no, so it is front of it. Okay, you know what? I know we've dealt with this before. Elaine can't comment on things that are currently in the system wise. So unfortunately, we can't give any advice. You already have something that's in the system and you have a hearing set. If there's something after the hearing wise and you need professional help, you can then jump in, right, Elaine? If
Absolutely. Yep.
Services. But I would say if you're dealing with the situation on your own and you haven't seek professional help, you should be. That sounds like a messy situation was.
Exactly. Yes. Thank you. So this is the kind of thing I see day in and day out. And like, you know, I guess I just want to qualify that often when I get these emails, it's people who have other representation and they're asking me for a second opinion and without documentation, without anything. And I won't do that.
Yeah, no. So, yeah, we also these are guidelines that we need to follow within our realtors have it, paralegals have it. There's professional things that we can't comment on things that are currently going on once they're in the system was.
Right.
There's representation that's already been entered into. I have my first hearing today. Applications made in March to evict for non-payment. Is it a good idea to get a paralegal involved as subsequent stages of the process wise?
No, not necessarily. I mean, if you're doing the hearing yourself and you get an order and the tenant doesn't pay, the next phase of that would be to book the sheriff, and you can do that on your own. If you, I don't think I've ever been retained just to go book the sheriff.
Oh, I would. I'd retain you to book the sheriff. I don't want to.
All right. Okay.
Elaine, I've hired movers to move me within my own house wise. People may think that's
okay. Well, I mean, I one of the things that I have a reputation about is to be really cost efficient for my clients.
Mm-hmm.
So, if there is something that I think that they can handle on their own, I will say that. I mean, it's not that I don't like to make money, I do, but I'm in for the long game, and if I can save a client some money, I'll try to do that.
For sure, yeah, and again, look at that honest answer right there. Elaine's not going to charge you money if she doesn't think there is a reason to charge you money. And for example, booking the sheriff wise, she could guide you where to go book the sheriff on your own if you wanted to do that. So.
This is a situation though that I would be very stressed going through, just myself. So just for, being able to pay someone, throw some money at it, have someone else deal it, especially in a very, personal situation, someone not paying, it can get very emotional. I would spend the money just for the reduction in stress personally.
Yeah. I 100% agree. Kyle and I have been working. He's becoming like Alex. Kyle wouldn't have said that.
He was Alex earlier, but that's a whole other thing.
How to file a request if payment agreement between tenant is not paid on time?
It depends, Mike, it depends on how you came to an agreement. If the agreement, if there was a file number associated with this, in other words, you'd already started an application at the board, then you can bring an L4 application. If you haven't started at the board, then you're basically starting from square one.
Okay, and Manny has now come back. Okay, so Manny is clarifying wise. He did a court action with the basement, but now his upstairs is not paying. He has no court action with that. He wants to negotiate that upstairs individual to leave wise. Can you help with that? And the answer would be, yeah, that's something that Elaine can help with.
Right. So I always say this, I can certainly try to assist. I have to have a cooperating tenant on the other side.
Of course.
But yes, by all means, I can assist.
Yeah, and I'll tell everyone here, and I've said this before, and I'm in the business of selling. Kyle's in the business of selling wise. If you have a tenant that you want to get out or you're concerned of wise, now Elaine may not be 100% on the same path as me, but you can just write a check and money talks. And if you can come to an agreement and tenant will leave, you can write the check. Now Elaine's going to say there is still no guarantee that person will leave on that closing date, but
there's a process that we have. I agree with you, and I
Yep.
do this quite often with my clients. But we don't just hand them a check. There's a whole process that we need to follow so that we can ensure that if they don't leave on that date, we're able to just call the sheriff and get them out. And sometimes we have to extend the closing by a couple of weeks, which is not a big deal. Well, sometimes it is, but compared to extending a closing by 6 or 8 months.
yeah. So Manny, the answer is yes, Elaine can help you wise. And sometimes it is, you have to write the check to get rid of the situation wise. And I do encourage you then to reach out to Elaine to help you with that situation. And hopefully the tenant is cooperative at that point.
Like right now, just on that note, I have an N12 owner's own use. Daughter needs the property to move back in. She's experiencing some difficulties because of COVID. And this tenant owes almost $10,000 in arrears. And I said, okay, I'll leave at the end of March, which isn't going to work for anyone. So we've waived the entire amount of arrears because we know we'll never see it anyway. And I have a termination date of December 31st.
Yep. And here's where it comes down to. So at the beginning of all of this, we talked about you own a property, you have hundreds of $1,000s in that property wise. Could be close to $1 million in the property wise. That's a lot of money. Money causes stress. On the other end, it's someone's home. That causes stress. You get attention, right? That exact example wise, now we brought in a whole family member, or so a family member actually does realistically need it wise. Elaine is able to look at it from a third party view wise going, this is the reality of the situation. You want to remove the stress of the situation. This is the road you're going to need to go on. And this is how we get it out. Sometimes when you're in that, you're blinded by how to get in and you're deep in the hole. So I just want to help people out here, and Manny seems to be in one of these holes right now. There is a road out of this hole, and I'm glad you're on this call, and I'm glad that hopefully there'll be some assistance that come to that. There's always a way out, and there's a way to start new on everything. So, and these are genuinely the worst case scenarios wise. Well, Elaine will say the worst case scenario is when you find, was it a cow or a horse in the property?
It's a cow.
Yeah, a cow in the property might be the worst case scenario wise. Don't think anyone's going to have that on this one. And then the last question here, the tenant has not paid for 6 months. His account is closed. The phone is disconnected, only email, which he does not answer email regularly. Hearing is next week. How do I get his contact? How do I get his contact as hearing goes my way? Okay.
Well, if the hearing goes your way, I mean, the board will have sent a copy of the application, notice of hearing and all that stuff to the rental unit by regular mail if an email has not been provided for the tenant. If he misses the hearing, you get your order, you call in the sheriff, and he's gone. You know, somebody's phone is cut off and is acting in the way that he's acting, the likelihood of you actually recouping your money is pretty slim. I mean, I hate
Yeah.
to say that, but I'm a realist, right?
Exactly. And I think to further, maybe Vinay's not familiar with the process wise. So if it does go your way and you don't have the ability to contact the individual wise, don't worry. That's the sheriff. The next step is the sheriff literally goes into the unit. This person has X number of hours to get out of the unit wise. And if the person doesn't get out of the unit, they will be physically removed from the unit. You don't physically remove them. There is a legal legal process to remove that individual. So that again that's the last, that's your last stand of defense wise in regards to, okay, if someone just says, I'm not leaving wise, someone, once you have the legal order and a legal representative, the sheriff wise will go in and then remove that individual. So again, there is always a way to deal with it wise. That would be the eventual end of the road. Hopefully you don't end in that road wise, someone physically removing someone, but there is a way to properly do that. And then Kim, last question here. What would Elaine do if the tenant didn't take that deal? Wait for hearing? I think the deal we were discussing would be the waiving of the rent wise.
Well, yeah, so I probably wait for the hearing, but the thing you have to be careful around with deals is you don't want to be seen to be harassing, so you have to handle them with care. You can't just be in a tenant's face going, take the deal, take the deal, take the deal. Why won't you take the deal? And there are landlords who do that because once you start doing that, you're actually opening yourself up to a whole other set of problems.
Great. Perfect. Well, you know what, guys, we'll wrap it up here. Thank you for taking the time. This will again be posted on our website, guys, and a recording will be sent out to everyone. We'll have Elaine's contact details there. I hope we were able to help people and you were educated wise. And we'll talk to everyone soon. Okay. Talk to
Be
everyone.
well, everyone. Stay safe.
Bye.
Everyone.
Bye.